Hello everybody, welcome back to our CMA classes. So we are going to resume our law class for CA final and CMA final students. So let's go to the continuation of inspection, inquiry and investigation. We are going for section 210, which says about the investigation into affair of the company. Okay, so the CG, if the CG is in opinion that it is necessary to investigate into affair of the company, okay, on receipt of report of whom, let's go and check who are going to say these on the report given by some people or by company or any other people. Let's go and check out. On report given by these people, the central government is going to take the action against the company. Which action? To investigate into affair of the company. Okay, let's go for it now. So on the receipt of report by whom? By the registrar. Do you remember section 206, 7 and 8, right? So yes, 208, the report was made by registrar, investigator, inspector under section 208, right? So on the report, on the receipt of report of registrar and inspector, on that basis the CG can go for this. Okay, let's go for the other part, which says this special resolution is passed by the company, okay, or any of the act is done against in public interest. In that case, CG will take the action. Okay, which action? To conduct, to investigate the affair of the company. Okay, and duty of central government to investigation, to order the investigation where the order is passed by tribunal or court. Okay, the CG shall order an investigation into affair of the company in 4 cases, right? When the receipt of report is given by registrar or inspector under section 208. Okay, special resolution passed by the company. Third was of the public interest, if any act is done against the public interest. And again, one more point was of tribunal. Okay, tribunal or court, when the order is passed by tribunal or court. Okay, in that case, CG will examine, CG will give the opinion to take the necessary action to investigate into affair of the company. Okay, hope so this was clear. Now, appointment of inspector by central government. CG may appoint one or more inspector to investigate into affair of the company, and the report is to be given by whom? To the CG. Okay. Now, this was, we are going for 211 section, which says about the SFIO, which is Serious Fraud Investigation Officer. CG shall establish an office to investigate fraud related to the company by issuing the notification. Okay, now composition of SFIO, let's see what are the points written in there. SFIO shall headed by the director, export and other officer. Yes, SFIO, so there should be one director, other employees and other officers. Okay, yes, SFIO shall constitute of such number of experts as central government may deem fit. The experts to be appointed in SFIO shall be the person of ability, integrity and experience in the following field of banking, corporate affair, taxation, forensic audit, capital market, information technology, law and such other field as may be prescribed by central government. Okay. Now, 212 says about the continuation of SFIO. Okay, investigation into affair of company by SFIO. SFIO is going to do the investigation on basis of whom? The power of CG to order investigation into affair of the company by SFIO, when the central government will give the order to SFIO on the basis of, do you remember what we read before? These point, yes, we have to cover these point. Okay, and there are also one more point other than these. When the receipt of report is given by registrar or inspector under section 208, right? When the special resolution is passed by the company, when any of the act is done against whom? Public interest, yes, or the department, central government or state government have given order to conduct the investigation. In that case, the CG will give order to whom? To the SFIO. Okay, Serious Fraud Investigation Officer. Now SFIO shall conduct the investigation and submit its report definitely to the central government, right, within the period as may be specified. Officer employees provide all the information, explanation, document and assistance to investigating officer, serious fraud investigation officer. We are talking about those. Okay? Now offense is to be recognizable and condition for release on bail. No accused people shall release on bail unless the opinion is given by public prosecutor. Okay, let's read it again what I said. No person, no accused person, okay, the person who have done any fraud under this section, okay, in that case the person would not get release, okay, on bail until unless the public prosecutor have given the order. Okay, now let's see what I have written. The public prosecutor has given an opportunity to oppose the application for such release. Hope so this was clear. But there are some cases when there is no need to go for the order of public prosecutor. Okay, and there if the special court so direct may to release on bail, in that case the public prosecutor have no right. Okay, in that case the public prosecutor have no right to oppose the application. Okay, and a person apart from those, if a person is under the age of 16, right, women, sick or infirm, in that case again the public prosecutor will not get the opportunity to oppose the application. Again I will repeat this, there are some cognizable condition to release on bail. Once the accused person will not get bail or on release, on what basis? On if the public prosecutor should give opportunity to what? Opportunity to oppose the application for such release first of all. Okay, but there are some exception. If the special court so direct, if the special court directs the order, in that case this person can go for bail. Okay, but there are some other condition which saying the person who is infirm, sick, women, or a person who is less than 16 years, below 16 years, in that case public prosecution is not, the order of public prosecution is not going to avail. Okay, now interim report is to be submitted by SFIO to whom the central government if it is directed to do so, in that case only. Okay, so the interim report shall submit to CG if so directed by the central government. Investigation report shall, it is necessary to submit to central government. Okay, hope so this was clear to you. Let's go for section 213. Now we have read there was something which was saying that the investigation is to be done on which basis? The report which is given by registrar and inspector under section 208, right? Other was of special resolution to be passed, and other was of public interest if the act is against public, done against the public interest, and fourth was of this, right, where an order is passed by court or tribunal. Now we have to check which people have right to go to give the application to tribunal. Okay, on that basis tribunal is going to give the order to central government. Okay, so let's check which people are going to be eligible, right? Investigation into affair of the company on an order made by tribunal on basis of what? 213, section 213 says about the investigation into affair of the company on order made by tribunal. The central government shall order an investigation of affair of the company if the tribunal makes an order that an investigation into affair of the company is required, as I told you in earlier section, right? So let's go for the member eligibility to make the application to tribunal. If the members are having share capital, they have two category. If the members are having share capital, if the members are not having share capital. In first case, let's go and check out. If the members are having share capital, at least 100 members, at least they should be 100 member, or one or more member holding 10% of voting power, whichever is lower, right? Again 100 member or one or more member holding 10% of total voting power. Okay, in case of share capital, we are going to take those people who are at least having 100 member. Those people who are having share capital, at least number of members should be 100 or 10% of voting power. ठीक है, one or more member holding at least 10% of voting power. ठीक है. Second case, when there is no share capital. So 1/5 of total number of member who are eligible can go for make the application to tribunal. Again, what I said in the earlier section, which was saying 210, was saying that the investigation is done on which basis? The CG will give the order, ठीक है, to conduct the investigation. For that investigation, we also read that CG will appoint SFIO under section 211. Okay, we have read the eligibility of SFIO and all, SFIO officers, employees and all, ठीक है. But under section 210 we read that there are some people, on the basis of application given by those people, the CG will give order to do the investigation to the inspectors, right? Now we have read that under section 208 the receipt of report of registrar, right, and inspector. Okay, special resolution is passed by the company, right. Third was of any of the act is done against the public interest, and fourth was of tribunal, right, if the order is given by court or tribunal. Now 200, what I said that 213 was saying about the application member of eligible to make application to whom? To tribunal. So this was the fourth point, right? This was the fourth point. Now we have to check for the two category. First was of share capital, second was of no share. If the person, the members are having share capital, in that case at least 100 members should be there, or one or more member who are having 10% of total voting power, whichever is lower among them, we are going to take it. ठीक है, but when we are going for no share capital, in that case 1/5 of total number of members who are eligible. Okay, in that case only, on the basis of application to tribunal, the tribunal will give order to whom? The central government. And once the order is received by central government, central government will make the order to whom? The inspectors, right? In that case, what is going to happen? The inspection is going to be conducted, right? Now, application to tribunal by any person or suo motu, by any person, we already read that which people, okay, these people, the criteria having the share capital or no share capital, okay, so these are those people, any people, ठीक है. So either the tribunal think, if the tribunal think any of the act is done against the company, which act? Now we have to read out. The tribunal is satisfied that any of the following circumstances exist. Okay, business of the company is being done in fraudulent manner, ठीक है, done in fraudulent purpose or fraudulent manner, unlawful purpose, oppressive of any of its member, with intent to default its creditor, member, any other person. Okay, let's read it again. What I said, that the tribunal can go for the what? The tribunal can go for make the application which is given by any person or by suo motu. And suo motu, when it's going to do by itself, right? The tribunal will give the order by itself to whom? The central government. What I told, and I told this part. Okay, but on what basis? If the business is conducted on fraudulent purpose, fraudulent manner, okay, or unlawful manner, any of the member, oppressive of any of its member is done by the company, okay, or with intent to default its creditor, members, any other person of the company. And one more point, person concerned information of management of the company is done by fraud, misrepresentation or misconduct. In that case, the tribunal will take the action, okay, to do the inspection against the company. Now let's go for the 214 section, which says the security for payment of cost and expenses of investigation, which says the payment is to be deposit to certain payment is to be deposit for doing this investigation. The company were having turnover up to 50 crore have to deposit the security amount of rupees 10,000. The company who are having turnover more than 50 crore to 200 crore have to deposit 15,000 rupees, and the company who is having turnover up to more than 200 crore, in that case 25,000 is to be deposited to the company. Okay, hope so this was clear to you. Now let's go for the last section, which says that the firm, body, corporate or associate not to be appointed as a inspector. Okay, this was of 215 section. So this was the last section of this lecture. Hope we'll meet in next video. Till then, to this guys, do the revision regularly.